Except for the provision for permanent residence, Section 6, which finds its mirror image in Article 35A, every other provision was really a mirror image of the Indian Constitution. So what is that an indicator of?
That's an indicator of the fact that
whatever is happening there is really the incorporation or the adoption of what is happening in the
I can only say this to your lordship. I can only say
of the Union of India.
I can only say this to your lordship. Either we interpret 370 sub-article 3 in its text and context, or we find something that's not there. And as a matter of constitutional law, you have to interpret the Constitution, not find a silence in the Constitution to interpret something that is expressed. Let's just read it, Notwithstanding anything in the foregoing provisions of this article, the President may, now who is the President? Acting on the aid and advice of Council of Ministers, may by public notification declare that this article shall cease to be operative, or shall be operative only with such exceptions and modifications and from such date as he may specify. Now just pause here. Supposing, he was not to abrogate, he was only to modify or apply with exceptions. Is that also unilateral power? Forget about abrogation for the moment. So we have to interpret constitutional provisions as we read them, not as we find some element of silence which is not there. Provided that the recommendation of the Constitution, this is a proviso, that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. That means to start the initiating of the process, that recommendation is necessary. And before the President issues the notification. It's a double emphasis of how that power can be exercised, not by Parliament, but on the aid and advice of the government. So,
we'll of course have to then, to accept your argument, we will have to read a further condition in the proviso that the recommendation of the Constituent Assembly has to be in the same terms of the action which is proposed to be taken by the President. Namely, either that if you are abrogating, there must be a recommendation that yes, abrogate.
Yes.
Or if you are making 370 applicable subject to such changes,
yes, same thing.
Then the recommendation must be also along the same.
Yes, yes, absolutely.
But that's not there in the proviso, isn't it?
It is, it is, before any of this. Kindly see, provided that the recommendation of the referred to in clause 2 shall be necessary.
This is a core argument on which you have taken one stand, the other side is taking another stand. We'll have to...
No, all I'm saying, at the moment is,
what their stand is that proviso will not evaporate and write off the third clause of Article 370 after the Constituent Assembly as...
at least it's
so far... Your stand is to the contrary.
So far, I can only go by precedent. So far, the proviso has never been interpreted in the fashion that they are seeking to interpret. In any judgment of the Supreme Court since 1950.
That occasion never arose, probably.
That's not the way they acted. Kindly please appreciate what they've done.
Therefore, according to you then, if the proviso cannot be applied because the Constituent Assembly has come to an end.
No, with respect I say, that's not the point.
Because the proviso says the Constituent Assembly referred to in clause 2.
Correct.
So it is only one Constituent Assembly which was formed for the purpose of the framing of the Constitution of J&K.
Correct.
Even if you have another Constituent Assembly in J&K, you can never have that Constituent Assembly which was for forming the Constitution.
No, let me answer.
Therefore, the proviso cannot apply at all.
Let me answer it.
In your submission?
Yes. My answer is the following. When the Constitution of India was framed in 26th of January 1950, there was no Constituent Assembly and there was no Legislative Assembly. So what did the Constitution makers provide for in the proviso? They envisaged that there would be a Constituent Assembly. They envisaged that there would be a legislature. If there was a Constituent Assembly which would abrogate 370, there would be no Jammu and Kashmir Constitution. There would be no Jammu and Kashmir Constitution. Because that's abrogation. Constituent Assembly would recommend abrogation. At that point in time, those who drafted the Constitution were not aware as to what was going to happen. That's why. Sorry. I'm sorry.
370 in the slide, there are two arguments. One, obviously, with reference that the proviso will not be controlling the main part of 3. That's a core dispute between them.
That's right.
Provision will not be applicable is contradiction in terms.
Now, let's put it differently. This whole process was a political process. That's what Salve argued, council argued. This is a political compromise. So you pull the plug anytime you want to pull the plug. At least 370 doesn't allow you to do that, but assume that's the case. If it's a political compromise, there will be a political solution. Why are lordships finding some constitutional solution that doesn't fit into this? That's not what your law, you have to, please look at it this way, Malad. If the process was political, the solution has to be political. Now, how that solution comes about is not neither for your lordships, not for us to suggest. This is something that they have to do in collaboration.
The initial part was political, now it has to be constitutional.
No, if that is so, if now it's constitutional, then that means that the Constituent Assembly...
Just look at it this way. The fact that the intent behind the article was temporary and transitory.
But that I'll come to a little later. But the answer to the question is that the Constituent Assembly was framing the Constitution of Jammu and Kashmir, knew that after that task was over, it would end, and was signing a death warrant under 370 sub-article 3 that now you can abrogate the Constitution. That can't. I'm sorry, Malad, on a plain reading of 370, I have the greatest respect for your lordship.
Therefore, the sequitur of your submission on the proviso to clause 3 is that once the Constituent Assembly has formulated the Constitution of J&K, which has been adopted, the proviso ceases to have any existence.
Yes, and 370 ceases to have effect.
Therefore, 370
ceases to have effect. 3 ceases to have effect.
Sorry, 370 or
sub-article 3 ceases to have.
Therefore, 370 bracket 3 ceases to have effect.
Yes.
In which case, 370 by itself, apart from 370 clause 3, assumes a permanent character.
It's permanent in the sense that what is left of this autonomy that we're talking about. If the argument is it is just a shell, what is it that you're trying to do? What is the argument today, Malad? I've heard it, Malad, several times over. What is left is only a shell. Everything is already there.
That there's a contradiction in their argument.
Well, I'm only saying, Malad.
Just one. Yeah. There's a contradiction in their argument. They said that main substantial part of the Constitution, including 356, is now fully applicable. But what was the main stumbling block was Section 6 and 35.
Because as far as 35 is concerned, that's a separate issue.
I'm not interpreting complete adoption of the Indian Constitution in toto, in completely as in case of other states.
Strike down 35A. Well, I don't understand where we are getting here. If this is the only stumbling block, you strike down 35A.
That's the judicial way.
No, that can't be politically done in any case. Because there can be reasonable restrictions and there can be classifications in terms of Article 14. It has happened in Uttarakhand, it has happened in Himachal, it has happened in other states, Malaj. It can't happen in Kashmir. Malaj, it is happening in Assam. You are fixing a date to people who came into Assam.
We'll come to that a little later.
Malaj, I'm only trying to, Malaj, indicate, show the mirror to myself that if it happens in Kashmir...
There's actually, I feel, the two spectrums which have to be decided.
Yeah.
When you use the word temporary, whether it is actually temporary in the sense they understand it, or it is temporary in the sense you understand it, that it was with the context of the Constituent Assembly, one. Number two, how you understand subclause 3 is that once the Constituent Assembly dissolves itself, 370 in the form it exists according to you is frozen in time for all times to come. Correct? This is what your argument is.
No, 370 sub-article 3, Malas. The rest of it is still remaining.
Yes, I'm saying 370, the remaining part is frozen as period of time because of the historical perspective.
No, not remaining, Malas. You can continue to integrate. 3 is frozen.
3 goes to the remaining part subsidy.
Yeah, absolutely.
They say no, 373 is not limited to that stage because of the manner COs have been issued and can extinguish themselves.
That COs have been issued not in under 3.
Then comes the methodology, whether they could have done it or not.
But the COs have not been issued under 3. This is the problem, Maharaj. These COs can continue to be issued. All of them are under 1. So, and Malas, I'm sorry to say this, when you talk of temporary provisions, it is not a temporary provision. Kindly
Mr.
look at-
Sibal, ultimately, therefore, it will boil down to this, that there is in our constitution, if we accept your submission, there is in our constitution a provision to which even the amending power, which is available in respect to the rest of the constitution, is unavailable.
It's unavailable because it's been amended. 368 has been amended with a proviso.
And there is, in that sense, a provision of the constitution which lies even above the basic structure of the constitution.
No, Malas, I mean, why do your
Because you
lordship say
cannot,
it is?
370 you can't amend also.
I'm sorry.
You can't amend 370 also.
It's not
To amend 370, you have to take the route of 368, and 368 takes you back to 371 by the proviso. Therefore, we would be then really accepting a situation. We're not saying it's unstatable. We're testing the proposition. Is there a part of the Constitution? The only restriction we have found so far in our jurisprudence on the power of changing or altering the Constitution is a basic feature doctrine. We are now going to add one more, which is that Article 370 lay even beyond Article 368, and much beyond the basic structure doctrine, because you can't touch Article 370. It assumes a character of permanence.
Well, this is getting more interesting. This is even getting more interesting. Well, let me now ask myself a question. Supposing I were to file a petition tomorrow in this court that the proviso to 368 is unconstitutional. 368. Supposing I were to file the petition, and what my lord is saying is upheld, is right. That how can you do that? Strike down the proviso to 368 and amend it under 368. There are hundreds of ways of doing the same thing, Malas, but we are testing the proposition in the context of what they have done.
The postulate that a judicial, in the exercise of judicial review,
what your lordships are putting to me.
We must take the proviso as a given.
But I am saying, yes, Malas, it's your lordships who are saying there's something silent in it which I don't see, Malas.